Good morning, everybody. I'm back again with another video for y'all. I am the Supreme Litigant. Before I begin, y'all already know the routine. If you haven't already, please go ahead and hit that subscription button, turn that notification bell on, and hit that like button. I'll give y'all a second to do that. All right, y'all. So let's jump right into this, as promised. This case, it is going to explain the jurisdiction of Admiralty some more, and I'm going to be providing y'all with some commentary just based off all of the research that I have done in relation to Admiralty jurisdiction. Let's see. This is an old case. I got this case from that website that I mentioned in the previous video. It's 1855. It's a California Supreme Court case, if I'm not mistaken. Is that Supreme? Let me see. I think it is. But anyway, so let's just start reading this. The judicial power of the courts of the United States in Admiralty and maritime cases is not exclusive, and the states have the power to confer that jurisdiction to its fullest extent upon their own courts. Interesting. Now, keep in mind that this is an old case, so that holding that you just read, it may be wrong. I mean, it may be overruled now because they so-called changed the laws or whatever you want to call it, or because judges, so-called judges, they err in their opinions. That's why they call them opinions and not facts, because generally speaking, none of them really know, for real, what it is. Some of them, like, they may know. But all of this stuff is just made up, as I've stated in the previous video. But let's get to it. The plaintiff in his complaint sets out that he entered into a contract with the streamer Columbia through her proper officers for the transportation of himself and family. Notice that they're talking about contracts and transportation. That should ring a bell right there. Together with their baggage from the port of San Francisco to the port of Crescent City in the state of California, that he performed all of his portion of the contract so entered into, paying his passage money, delivering his baggage, and embarking his family. At that time of filing the complaint, the steamship was and had for a long time past been plying between the ports of San Francisco in said state and Portland in Oregon Territory. Notice they calling it a territory right there. Interesting. Touching at intermediate ports, that upon the arrival of the steamer at the port of Crescent City, the defendant who refused to deliver the baggage and still refused to deliver the same. Give me a second, y'all. My phone is ringing. One moment. Okay, I'm not even sure where I left off. Okay, right here. That by that detention from business in his attempts to procure the baggage, he has sustained damage to the amount of $1,500, that his damage for the loss of said baggage had amounted to $566, making the total amount of his loss $2,066. To this, the defendant alleged several grounds of demur. So it's like a dismiss or whatever. Among the most important of which were the following: that it appears upon the face of the complaint that the court has no jurisdiction of the person of the defendant. So they're talking about that's in personam jurisdiction right there. That it appears upon the face of the complaint that the court has no jurisdiction of the subject of the action. They're talking about subject matter jurisdiction right there. The court overruled the demur, which is the motion to dismiss, and the parties proceeded to trial. The jury found for the plaintiff and assessed his damages at $1,422.50. The defendant appealed. That's a very good brief summary of what happened in the appellate court. That's how you're supposed to do it, y'all. Now pay attention, y'all. The action is a statutory proceeding in realm under the act entitled An Act to Regulate Proceedings in Civil Cases in Courts of Justice of this state, passed April 29, 1851, Chapter 6, of which is headed of actions against steamers, vessels, and boats. Notice this is a legislative act, y'all, with statutes and codes. Admiralty courts are civil law courts. Civil law is statutes and codes. I'm just pointing that out, y'all. The fifth section provides that an action may be brought against a steamer, vessel, or boat for the non-performance or the malperformance of any contract for the transportation of persons or property made by their respective owners, masters, agents, or consignees. Our purpose is to show that this statute being unconstitutional and void, the court below could not entertain jurisdiction either of the person of the defendant or the cause of action. The complaint shows expressly, I'm gonna point this out to y'all, because this is what I mean by you have to plead facts that show that you're seeking an equitable remedy, or you have to plead facts in the nature of the jurisdiction of equity. In this particular case, the complaint pled facts within the nature of admiralty. I'm gonna point that out to you. The complaint shows expressly that the steamer Columbia is a marine vessel plying on the ocean on tide waters exclusively, and now and for a long time past has been plying between the ports of San Francisco. Notice they have quotations here. He's quoting what the allegation was in the complaint. In said state and Portland, in Oregon Territory, touching at intermediate points. This makes the Columbia a subject of the jurisdiction of admiralty courts. This fact right here, that allegation in the complaint right there, tells the so-called judge the nature of the action. That fact, right? That allegation, that fact right there. And not only that, the remedy that he's asking for. Let me see. This makes I already read that. Let me see. The Admiralty has jurisdiction over all roads, harbors, and rivers which are not within the body of a county. And then there's a case right there to support that conclusion. Steamboats and lighters engaged in trade or commerce on the tide waters and the seamen employed on board are within the Admiralty jurisdiction. And here's more cases right here. These are cases that they're citing in support of what they just said right here. Everything before this period right here. This right here. These are the cases that they're citing in support of that. The cause of action is the breach of a maritime contract between nothing more than a contract of passage for the plaintiff, his family, and baggage. So what this is saying is this contract that this guy entered into with this steamboat or whatever, it's a maritime contract. That's where the jurisdiction of admiralty attaches. If it is a maritime contract, then the jurisdiction of admiralty is going to attach to it. Okay, moving along. To bring a case within the admiralty jurisdiction, it is sufficient if it appear by reasonable implication that the case is a water transaction, though it be not so stated in express terms. Pay attention, y'all. If the subject matter of a contract relates to the navigation of the sea, though it be made on land, The Admiralty has jurisdiction. Here's all the cases right here that support that contention. This case is 7 pages long. It's short, sweet, and straight to the point. This is why you need to read old cases. So much for the cause of action and the person of the defendant. Now, as to the statute, we affirm that the legislature could not have conferred admiralty jurisdiction by proceeding in realm on the common law courts of this state. Admiralty jurisdiction is founded for the most part on the subject matter and not solely on the place of making the contract. Let me read that for y'all again, for these motherfuckers who want to call us sovereign citizens and we crazy. This goes out to you stupid ass police officers who don't read. This goes out to you, some of you attorneys who think people are crazy, who are on video, on video on YouTube making videos and calling people crazy when they bring this stuff up in court, and you call us crazy. You are not an attorney at law. At law means common law. There are no statutes in common law or equity. None. You are not an attorney at law. In my opinion, you are an attorney in maritime or in admiralty, probably both, because they are using statutes and codes in these so-called administrative courts. They are not courts. I don't care what the fuck they call it. Anyway. Admiralty jurisdiction is founded for the most part on the subject matter. When they say subject matter, they're talking about the subject matter of that contract, and not solely on the place of making the contract. The admiralty jurisdiction in cases of contract depends upon the subject matter of the contract, like I just said. In cases of tort, it depends upon the locality, viz., whether the transaction occurred on the high seas or in the ports within the ebb and flow of the tide. In cases of torts are private actions, if I'm not mistaken. The admiralty jurisdiction attaches when the tort has been committed within the ebb and flow of the tide, although it be infra corporis, comitatus. So I'm going to pause the video because I want to know what that means. I'm going to pause this video and I'll be right back. Okay, y'all. So I went and Googled those terms. Let's go back to the case to make sure that I got them correct. I think I do. Infra corporis comitatus. Okay, I got it. Infra corporis comitatus. Okay, that's it. So let's see what it means, y'all. Infra corporis comitatus, or whatever, means within the body of a county. In English law, it referred to a body of water that was completely surrounded by land and therefore not subject to admiralty jurisdiction. Okay, so let me go back and read this again in paramount or in conjunction with that or whatever. In cases of tort, the admiralty jurisdiction attaches when the tort has been committed within the ebb and flow of the tide, although be infra corporis. Okay, so it says although it may be on land. I'm guessing that's what it sounds like. It's saying even though it says although be infra corporis tatus. So although it happened on land, I don't know. It seems like it's a little. No, I think I got that right. Y'all let me know if y'all think I'm right in regards to that, because I'm still studying this stuff just like y'all. But if I understand this correctly, infra corporis comitatus, or however you pronounce it, it's it is not within the jurisdiction of admiralty, generally speaking. So it has been committed within the even flow of the tide, although it may be on land. So it seems like a tort that comes within the jurisdiction of Admiralty can be committed, although although it happened on land. It seems like that's what it's saying. But I also found something very interesting within this definition. There's a different definition, and this one's called corpus comitatus, means the body of a county, and refers to the area within a territorial jurisdiction where Admiralty did not originally extend. That is very interesting. I think I need to study that because so it seems like it's suggesting that within the territorial jurisdiction of a so-called county or state or whatever, that's where the Admiralty jurisdiction is. If it did, although it did not originally extend to there. Something like that. Don't hold me to that, y'all. I'm still studying this stuff, y'all. So just bear with me. This is a more thorough explanation. Okay, let's see something. Examples, explanations. Okay, a lake that is entirely surrounded by land within a county would be considered infra corpus comitatus and not subject to Admiralty jurisdiction. That's interesting. Explanation. This means that if a legal dispute arises on a lake that is entirely surrounded by land within a county, it would be subject to the jurisdiction of the county court rather than Admiralty jurisdiction. Okay, so I might have got that contention wrong, what I said a little earlier. This term is important in understanding the historical development of legal jurisdiction in England and how it has evolved over time. This is very interesting. This is how you learn, y'all. This is how you do research. So let's get back to this case. I don't want to get too much off point. Let's see. Where are we? We stopped about right. Okay. By the Constitution of the United States, it is declared that the judicial power shall extend to all cases of admiralty and maritime jurisdiction. And it is further declared by the Judiciary Act of the 24th September 1789 that the District Court of the United States shall have exclusive original cognizance. So they're talking about exclusive jurisdiction of Admiralty. Now, I just told y'all in another video, I think the video that I did before this one, that the U.S. District Court, they have jurisdiction over, Admiralty, maritime, quasi-common. I'm gonna call it quasi-common law and quasi-equity. It's really not. I don't really call it. It's really not either. I think that's something within their so-called territorial jurisdiction. With I think I would call it plenary power. I think that's the more appropriate term to use because it's not there's no statutes in common law and there's no statutes in equity. But when you file your 42 Section 1983 lawsuit in here, you're using a statute and you're filing it in the District Court of the United States. Are you not? And you're asking for a colorable common law remedy, which is money damages. But there's no money. Federal Reserve notes are not money. It's only the appearance of money. See what I'm saying? But let's keep going. By the establishment of the District Courts of the United States, the state courts of Admiralty have been superseded. Okay, and here are all the cases right here in support of that contention. Now, I want y'all to notice that it doesn't seem like that these are cases coming from within this so-called country. It seems, well, this one might be, but some of them don't seem like they seem like they're from overseas or something like that, which is probably true because this is an extremely old case. And that's how I know that's how they did it in Alabama when they were first starting with their case law. They would cite cases from England in support of their arguments in Alabama. Okay, so let's see. The courts of the several states exercising Admiralty jurisdiction having been superseded by the organization and establishment of the District Courts of the United States, the question remains, do the common law courts of the several states possess any admiralty jurisdiction? And if they do, what are the characteristics and extent of such jurisdiction? The common law courts of the several states possess, in some cases, a concurrent jurisdiction for the Judiciary Act of the United States. States leaves to suitors at let me rephrase that. For the Judiciary Act of the United States leaves to suitors a common law remedy when the common law is when the common law is competent to give it. Okay. So it's concurrent. So it's concurrent means it's the consecutive is back to back. Concurrent is at the same time. It's simultaneously. Scroll down a little bit more. In the case at bar, the plaintiff is not seeking a common law remedy. No, he's not. But is invoking the aid of a statute of recent existence. Pay attention. Did y'all hear what he just said? Even though he's asking for so-called money damages or whatever, and money damages is a common law remedy, I might be misconstruing this, but anyway, in the case at bar, the plaintiff is not seeking a common law remedy, but is invoking the aid of a statute of recent existence. This is conclusive of the case. What are the cases in which a common law is competent to afford a remedy? There can be no question that its powers are of no avail in affording a remedy by a proceeding in realm to enforce the exercise of admiralty jurisdiction. So in realm is against a thing. Apart from the recent statutory enactments in some of the states, the process in realm is known to the civil law only. Civil law statutes and codes, y'all. I just told y'all that, and they've already established the nature of this action by telling you that it is within the jurisdiction of admiralty, and we talking about civil law because he's the whoever filed this complaint it's really not a complaint because in admiralty they don't call them complaints, they call them libelants or libels. The one who files the libelant is called the complainant. That's what they call it. Let me see. Apart from the recent statutory enactments in some of the states, the process in realm is known to the civil law only, from which the admiralty has borrowed it. Courts of common law do not proceed in realm, or the words of Chancellor Kent. Chancellor is a euphemism for a judge of equity, so to speak. And he has here's the cases that he's citing in support of that, what he just said. What, however, is the admiralty jurisdiction of the common law courts when the common law is competent to afford a remedy? In all transitory actions, I did some research on that. I think it's I forgot what that damn word was, but I did some research on it. But I don't want to make this video too long, so I'm gonna just keep reading. In all transitory actions, when the process is in personam, whenever the person of the defendant is brought within the jurisdiction of the court by its process, the common law courts, both national and state, can exercise a concurrent jurisdiction. I think transitory actions is when an action is brought in an admiralty court and another action is brought in a common law court when the process is in personam. I think that's what it is, if I'm not mistaken. But anyway, that's really not important right now. The peculiar function of venue by which all actions of a transitory nature or entertained in the forum where the suit is commenced enables that forum to entertain jurisdiction wherever the cause of action may have arisen, whether on land or water, on the high seas, in harbor, within the ebb and flow of the tide, or on dry land. Blah, blah, blah. The saving clause in the Judiciary Act of September 24th, 1789 was not intended to confer a new jurisdiction upon the courts of common law. And to bestow a remedy unknown to their powers by proceeding in rem, but to preserve the jurisdiction by process in personam. Interesting. But in the case at bar, the defendant is confessedly, by the complaint, a maritime vessel used in plying upon the high seas and not used or intended to be used in the navigation of the interior waters of this state. To such vessels so used and intended to be used, a maritime lien to be enforced in the district courts exercising admiralty jurisdiction can alone attach. There are similar acts to the statute of this state in the other states of the Union. The statute is similar in the extreme of the act of the state of Missouri. But the act of Missouri does not infringe upon the Constitution of the United States, as the proceeding in rem under the act extends only to boats navigating the waters of the state exclusively. Okay, so that's not international, nothing like that. The admiralty jurisdiction of the courts of the United States does not extend to rivers, but is limited to contracts to be performed and acts committed on the high seas or within the ebb and flow of the tide. The Thomas Jefferson Peters, blah, blah, blah. Let me see. The courts below erred in overruling the demur, and the courts of common law in cases like the present have concurrent jurisdiction with the admiralty. Blah, blah, blah. No conflict can arise, as the jurisdiction is determined by priority of process. Okay, so now we're going to get to the opinion of the court. I actually thought I was reading the opinion of the court, but that wasn't even it. Okay, so who is this? Justice High Defender, I don't even know how to pronounce that. Delivered the opinion of the court, blah, 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 concurred. Okay. In the case of Averill versus the steamer Hartford, 2nd California 308, we decided that the act providing for actions against steamers, vessels, and boats confers upon the district court's admiralty jurisdiction pro tanto. Not sure what that is, but anyway, and the proceedings in such actions must be governed by the principles and forms of admiralty courts, except when otherwise controlled or directed by the act. Notice they just keep talking about acts. It is argued by the appellant that the act is unconstitutional because the second section of the third article of the Constitution of the United States declares the judicial power shall extend to all cases of admiralty and maritime. In the case of Gordon v. Jordan, 4 California 368, we had an occasion to examine and settle the proper rule of construction as to the judicial powers relatively to the federal and state governments, taking as our point of departure the universally conceded principle that the states are original sovereigns with all powers of sovereignty not expressly delegated by the federal compact. We adopted as the test between the delegated and reserved powers. The rule laid down by the earliest and ablest commentators on the Constitution, Hamilton, Madison, and Jay, are each alike responsible for the positions maintained in the Federalist. And two of them at least are favorable to giving every latitude of construction which could strengthen the power of the central government at this at the expense of the reserved powers of the states. Notwithstanding this tendency, the general rule of construction which they favored is warranted by the soundest reasoning and the justest comprehension of the complex character of our government. To deprive the states of any power belonging to original and absolute sovereignty, it must be shown that the grant of the power to the United States is, by the language of the Constitution, exclusive, or that it is expressly prohibited to the states, or that from the nature of the power, its exercise by both is incongruent, what is that? Congruous, whatever, I don't even know how to pronounce that word, and incompatible, or in the language of Mr. Hamilton, absolutely and totally contradictory. I'm stumbling over my words. I'm sorry, y'all. And repugnant. The objection to the jurisdiction with which the legislature of California has conferred upon the courts of the state can only be argued upon the last proposition of the rule, because in the clause of the Constitution of the United States giving that power, or elsewhere, there are neither words of exclusive grant nor prohibition. Okay, so let's see. Is the exercise of the jurisdiction by the courts of both governments contradictory and repugnant? Certainly not mere so, certainly not more so than the exercise of jurisdiction in the large numbers of cases in reference to which all authorities admit the powers of the two courts to be concurrent. And indeed, it may well be questioned whether the object is not more insignificant when applied to most cases of admiralty and maritime jurisdiction than any other class. For in these, the general principle is that jurisdiction is acquired by seizure of the thing. The thing. Notice they said the thing. They're talking about admiralty when they say thing, which, once seized, must be disposed of by the court whose process holds it, so that conflict of jurisdiction is out of the question. This subject, however, was fully examined in the case of Gordon v. Johnson, before cited, and we are satisfied to adhere to our treatment of that proposition as it was laid down, as then laid down. It results from the views we have taken that the states are not deprived by the Constitution of the United States of the power to confer upon their own courts all admiralty and maritime jurisdiction, that consequently Congress has no power to make this jurisdiction exclusive to the federal courts, and that therefore the act under review of the California legislature conferring admiralty jurisdiction upon the district courts of the state is constitutional and valid. Judgment affirmed. So anyway, I think this is a pretty good case. This is why you need to go and read old cases, because they're very generally speaking, they're very simple to read. You may have a little problems with it, but you just keep reading and keep reading and keep reading, because you're learning another language. So you got to keep reading and just make sure you understand the terminology that they're using and the context that is being used in. Hopefully this video helped y'all. That will be the end. The Supreme Litigant is out. Peace.